Senior Advocate of Nigeria and currently the President of the Nigerian Bar Association. He is a Fellow of the Chartered Institute of Arbitrators and the founder and senior partner of the law firm Paul Usoro Co. However, Paul Usoro's professional acumen, together with the rest of the body of Nigerian lawyers, is currently being engaged by developments in the polity in the last 24 hours, following the suspension and subsequent replacement of the Chief Justice of Nigeria, Walter Onnoghen, by President Muhammadu Buhari. We are now being joined by the NBA President to look at this development. Good morning, sir, and welcome to the show.
Thank you.
As we said earlier, it is a really dark day for the judiciary and also for democracy in Nigeria. The Nigerian Bar Association calls the suspension and replacement of the Chief Justice of Nigeria a coup against the judiciary and the Nigerian democracy. Can you please tell us and expand on how the association is feeling, what this means for Nigerians, and really at the end of the day, we're going to get into what happens next.
Well, it's that's a bit of a very long and twisted question, but I'll try to break it down. The focus of the Nigerian Bar Association is actually on the rule of law and following due process. In any case, you can't promote the rule of law if you do not follow due process. And the issue for the Nigerian Bar Association is what happened yesterday is not provided for in our statutes. It is not provided for the president to suspend the head of the judiciary, the Chief Justice of Nigeria. What is provided for by the Constitution is if the president believes he should remove the head of the judiciary, he needs to approach the Senate and he needs to have a number of the Senate, 2/3 majority of the Senate, requesting him to remove the head of the judiciary. Outside of that, the head of the judiciary is guaranteed a tenure up to his retirement age. And that is not what happened yesterday. So that due process is actually a problem for us. It is a big problem, not only for the Nigerian Bar Association, but for the justice sector as a whole, and indeed for Nigeria as a whole. Because once you tamper with due process, once you tamper with the rule of law, then really Nigeria is in grave, grave danger. It's in a very serious danger, and that's where we are right now.
But the president is purportedly obeying a court order issued by the CCT. This court order has been challenged by the coalition of opposition political parties, and they claim that they believe that the order was backdated. What is your view on this?
Have you seen the order yourself?
I have.
Okay. Were you following the process of...
I was. There's a subsisting Court of Appeal order to stay proceedings.
Yeah, but let me even leave that issue of the Court of Appeal order. Let me go back, let me take you back to the process, the proceedings of the CCT, that's the Code of Conduct Tribunal. You know the Code of Conduct Tribunal sat on 22nd?
Yes.
And there was a motion before the Code of Conduct Tribunal asking for the suspension of the Chief Justice of Nigeria. That motion was served on the other parties. And once they have notice, you have no need anymore for an ex parte order. You have no need for an ex parte application. And the courts, the tribunal, not the court, the CCT, in its own wisdom, on the 22nd, adjourned proceedings to the 28th. That's the coming Monday.
And this ex parte order is dated Wednesday, January 23rd.
That's precisely the point. That's a day after the tribunal had adjourned its proceedings to Monday. I'll tell you what happens. In those type of situations where there is that, if you permit my using that word, what appears to be judicial rascality, the courts, the appellate courts traditionally descend very heavily on the courts that commits such infractions, because that clearly is an infraction. You can't behind the back. When you have the parties, they should have notice. I'm not even getting into the merits of whether there should be something like that. But to obtain an ex parte order in that manner If indeed it was, if it's indeed it's a genuine document, then it is something that even the president should have frowned upon. The president himself, if he has these facts, then the president should have questioned the process. That's number one. I read the president's address. The president said that the Chief Justice has descended on a small arm of the judiciary, and that is the CCT. Clearly, the president hasn't been properly advised by his officials, because if he checks the statute books, then he would find that the CCT is actually under the presidency. It's not a part of the, it's not a part of the judicial structure at all. And in fact, even for the optics, it is wrong for the president to use an organ of the executive, because the CCT is under the presidency, even by statute. It's under the SGF, which is under the presidency. And it is wrong for the president to use that organ for the purposes of having to remove the head of the judiciary. The whole essence of the rule of law and separation of powers is that these different three arms should be separate and independent. And when you, as an executive, become not only the prosecutor, but also the judge in your own course, there is definitely something wrong with that process.
Staying on the president's address, he criminalized the Chief Justice by calling the six-count charge against him a corruption trial.
Yeah.
False access declaration and corruption are two distinct. Can you please explain regarding Section 23, subsection 2 of the Code of Conduct Bureau and Tribunals Act? It doesn't even prescribe a jail sentence.
You see, again, I would be, let me put it this way. The president is not a lawyer. So I would lay the blame more on his handlers who are lawyers, because they ought to know that the Code of Conduct Tribunal does not have the competence, it doesn't have the jurisdiction to try any corruption case. Corruption cases are tried by the high courts. So if indeed the government felt that the Chief Justice of Nigeria is corrupt, as the president purports, then clearly it is also wrong for them to have filed those proceedings before the Code of Conduct Tribunal. The Code of Conduct Tribunal does not have the competence to try corruption cases. Now, what does the Code of Conduct Tribunal do? The Code of Conduct Tribunal is essentially supposed to look at whether you had declared your assets or if you had falsely declared your assets. And of course, the sanctions that are supposed to be imposed, they are well stipulated in the acts. But in any case, their competence and their jurisdiction does not include having to try corruption cases. And you will not hear of any government itself. They know where corruption matters are being tried.
Yes, it's clear in the act.
Yeah, that's very clear. So, like I said, the president clearly is not a lawyer. Therefore, he might not understand the distinction between the asset declaration and the matters that are handled by the CCT and the corruption matters that are handled by the regular courts. So I would make that excuse for him, but then it's difficult to make that excuse for those of his officials who advise him and who are lawyers. But second, maybe what the president also should do is when there are matters like this, he should also reach out, ask opinion, what is the correct position as far as the law is concerned.
There's another error in his address where he stated that the CJN's own written admission to the charges that he failed to follow the spirit and letter of the law in declaring his assets are totally unknown to our laws as defenses in the circumstances of this case. This is false. The vice president was one of the counsel to Tinubu in 2011. Do you recall?
Yes, I do.
He admitted,
absolutely.
and that's also in the Act, Section 3D of
Yes.
the CCB Act.
Yes, yes.
So what do you attribute these kinds of
No, well, again, I would not get into the merits. I would not even get into whether there is a defense of that nature open to the Chief Justice. What I would say in regard to that particular point that was made in the President's address is it actually brings the executive into the realms of becoming the judiciary. Because with great respect, the executive has no business having to talk about whether the Chief Justice has admitted and it amounts to a liability. That is something that needs to be pronounced upon
by a court. He's rejecting that as a defense. Does the president have that power to reject a defense?
No, that's precisely what I'm saying. It has to be pronounced upon. Now, you see, I made this point when I was on your television the other time. I said, even in criminal matters, proper criminal matters, not this asset declaration, proper criminal matters, you find an accused person, he writes a confessional statement. The law says until he's gone through that process and then that confessional statement is admitted, it is held to be indeed of probative value. And that is the only circumstance that the court can act on it. In this case, they say and they purport that he has admitted it. You don't know whether he has defenses. It can only be tested in a proper tribunal or courts. Let the proper process go through. And we have said, this is actually a matter, because he's a judicial officer, let it go to the National Judicial Council. Why are we speculating as to what the National Judicial Council will do? And let them have a look at the whole raft of issues, including whatever he's purported to have admitted. Does he have defenses? Hear him out, and then make a determination. What I expect, with great respect to the President, is the President to actually encourage that principle of hearing the other side and following due process and upholding the rule of law should be what the judiciary should do in this particular instance. I expect him to encourage that. And the reason I expect the President to do that is very simple. He swore to uphold the Constitution. And that is part of the responsibility that goes with having to uphold the Constitution.
So taking a look at this case, and actually when you look at the outrage from Nigerians are outraged by this action that happened yesterday. What does this say about the professionalism of Nigerian lawyers, especially those advising I'm sure there are people advising the President, but also, what is this? Is this an indictment on our judiciary as a whole, or is this an indictment on the President?
I don't see how this is an indictment on the judiciary. The fact that the executive arm of government decides to encroach into a territory that it should not, you do not blame the victim. You blame the aggressor, the person who has decided to encroach into a territory that he's not supposed to encroach into. Let me pick one other thing in regard to and which portends very grave danger for all of us.
The President's remarks.
Yes, the President's remarks. One of the reasons he's also given in his speech is that the Supreme Court has been upturning certain corruption matters that they have taken to the courts.
The number of acquittals in corruption cases,
exactly.
Yes. He specifically mentioned
He
that.
did. He specifically, with great respect, that ought not to be even said. You don't even say it. Because what you are saying, in effect, is we have a mindset, we have already convicted this fellow, and it doesn't particularly matter what the court says. And we expect that you should read our scripts and follow our scripts. And when you do not follow our script, then it means you're not for us, you have given a wrong judgment. That is not the position. The independence of the judiciary means the judges themselves are also independent, and they should be able to make their determination. And when it gets to the apex courts, if the apex court makes a decision and says this is where it stands, that's the end of it. You might agree with them, you might not agree with them, but where you do not agree with them, you wait let the matter come up again. You can request or pray the courts to reverse itself. But you do not castigate the courts. You do not condemn the judiciary and decide that because they have not given a decision that is favorable to you, therefore, either they are corrupt or they are actually condoning corruption or they are not joining you in your fight. It doesn't work that way. That actually is undermining the rule of law. And that is an area that I believe that we should be very, very worried and concerned.
There's worry, there's concern. What are action steps now that can be taken against the executive?
Well, one of the first actions that the Nigerian Bar Association has taken is actually, we released a statement yesterday and we called on the federal government to reverse its decision because it doesn't portend well for the country. And that is the first line of action that the Nigerian Bar Association can take. We also invited the National Assembly to also join hands and condemn the action. And seeing as it's their powers as well that has been eroded, then they also need to be able to address the executive and let the executive know. The other line of action that something like this calls for, which we have also explored and we're still exploring, is also to reach out and sit down with the members of the executive and let them understand our perspective, particularly those of them that are lawyers. They're not going to be in those offices in the executive forever. They will get back here and join us. Would they be proud if they were in this side of the divide, so to speak, and they see the judiciary, the rule of law, being undermined the way it is being undermined right now? I don't expect that they would be proud. And they themselves need to speak up and tell those who may not understand within the executive that things ought to be done differently. But by the way, still on what needs to be done, the Nigerian Bar Association has called for a meeting, and we're going to discuss fully everything in regard to what has happened and how best to approach it.
What is Nigerian Bar Association's message to Judge Ibrahim Tanko Mohammed?
Well, I have the greatest respect for his lordship. I have the greatest respect for his lordship. I sympathize with his lordship. But what I would, and I believe that his lordship has these points that I'm going to raise in mind. There have been instances when there have been similar infractions, mainly at the state level. And the position of the National Judicial Council has always been that when the governor invites another judge to take over from the chief judge without following due process, that the judge who accepts to take that responsibility commits an infraction. I know that His Lordship, Honorable Justice Ibrahim Tanko, is aware of these decisions. He's a member of the National Judicial Council, and he was part of the decisions that were made in those circumstances. And I am fairly certain that His Lordship himself would be reflecting in the present circumstance. And I believe, I have complete faith in His Lordship that His Lordship would do the right thing as far as this matter is concerned, given those precedents, those decisions that had been taken and which, from all indications, they more or less have now played. It used to be at the state level. Now, that type of incident is playing out at the federal level. And I know that Justice Ibrahim Tanko Mohammed, being an astute jurist himself, he would consider those matters very carefully and would do the right thing.
But will he, since he's already been sworn in, will he, because this, the Abia State case where Justice Orji was sanctioned occurred just last March. His Lordship was a member of the National Judicial Council at that time. He's fully aware, he's in full possession of the facts. Yet, he sneaked out, reportedly, of his office and went to be sworn in by the president. Do you think his conscience will suddenly awaken at this point?
Well, I wouldn't put this in the language you have put it. I would rather say that I have not had the benefit of speaking with Justice Tanko Mohammed. And don't forget, I have just spoken here that it is necessary to give one the benefit. For me, the process that was used in the Abia State, the NJC actually listened to the parties and reached a decision. And whether it is Justice Onnoghen or Justice Ibrahim Tanko, the position of the Nigerian Bar Association is that due process should be followed. If Justice Ibrahim Tanko has infracted in this instance, then that matter would have to be taken up by the National Judicial Council, and then a decision would have to be made. And then he could be sanctioned. So for the Nigerian Bar Association, we must be consistent. A process has to be followed. I personally, I am hopeful, and I believe since Justice Tanko was part of that decision that was made in the case of Abia State, I believe and I expect that he would take note of that decision, and in whatever he decides to do, whatever he has already done, that he would make sure that that decision of the NJC is not made nonsense of, and that he can defend it.
I also wanted to ask you, how optimistic are you? Obviously, you have said you're going to follow due process, you're going to reach out and have discussions. How optimistic are you? Since parties in this situation seem to be quite entrenched, quite determined. Last year, the NBA was forced to issue a statement trying to rebut the president's assertion at your annual general conference that the rule of law is subject to national interest. How optimistic? Well, at that point, statements were issued, and we can see, in view of recent events, the statements went in one ear and out of the other. How far are you prepared to take this?
Well, I think that decision is going to be made on Monday. As I mentioned to you, the highest decision-making organ of the Nigerian Bar Association will be meeting on Monday. So by Monday, when we all meet and we have our own conclave, we'll come out with a decision and we'll know exactly which way we're going. But one thing I can tell you, the Nigerian Bar Association is consistent that we must not undermine the rule of law. The Nigerian Bar Association is consistent that the independence of the judiciary must be held sacrosanct. It must be defended. Without that, even President Buhari himself is not safe. He may not be president tomorrow, and he would need the judiciary. It's for all of us. We say it commonly that judiciary is the hope of the common man. It's not only the common man, even for the high and mighty. If you destroy the judiciary today, and you may need the judiciary not necessarily on political matters. If you destroy the judiciary today, and you want to have a judiciary, as the statement of Mr. President suggests, a judiciary that only says what you like to hear. Tomorrow, you may not need that judiciary to say what the man in power wants to hear. But because you had set a pattern, that pattern might come back to haunt you. So it's better not to set that precedent.
What recourse is available now to the Chief Justice of Nigeria, Walter Onnoghen?
The recourse that is available to him and the recourse that is available to all of us, we all need to also use the judicial process. For him in particular, he's a lawyer, he's the Chief Justice, and everybody looks up to him to uphold rule of law. And he has, I haven't spoken with him, by the way, but he has access to the courts, and he can test the validity of the ex parte order that the president purports to be obeying.
Wow. As you sort of see this process now, we're going into, the week next week. What are some of the actions, Like if we were looking at from Monday on, what are some of the actions that you would like us to see? What participation and what should we expect from the National Assembly going into this process?
The action that I would like you to see, very simple. Let the president reverse the actions that have been taken. That really is what I would like all of us Nigerians to see. The Court of Appeal made an order directing that the CCT, that is the Code of Conduct Tribunal, should stay proceedings until the decision of the Court of Appeal on whether or not it has jurisdiction as far as that matter is concerned is delivered. And that decision of the Court of Appeal is supposed to be delivered this week. I think it would have been right and proper for the parties to hold their themselves and keep their gunpowders, yes, until that ruling comes out. And I would also say one other thing that perhaps we should expect is actually for the federal government to affirm once again that it respects the independence of the different arms of government and that the rule of law is supreme. And that is by having to follow due process. That is what the Nigerian Bar Association would expect as we go into the new week.
As a Nigerian, if you look at some of the headlines that have come out over the last 24 hours, they have called this action dictatorial. They have called this a coup d'etat in conjunction with you. As a Nigerian and also as a man of the law, what does this say to you, and how do you go back and sort of process this and explain this to the next generation of Nigerians when we see actions like that?
It's unfortunate that all of this should be happening. I read the president's statement about how orders are being procured in a hurry from different courts. And I found that rather curious, considering the fact that the executive arm of government, they received a petition supposedly on the 9th of January. And by the 10th of January, the processes for having to remove the Chief Justice was already ready, and by 11th, the matters were already filed. In fact, the drafts of those documents were ready by the 10th, even before they had the opportunity to meet with the Chief Justice on the 11th. And then the matter was fixed for the following Monday, and the motion had already been filed for his removal. I think the president should also speak to his own people and talk about the undue haste and what it speaks about the entirety of this process. And that's where it should be. It's always wise and it's good to do that self-cleansing, and then you can talk about other people, the need for other people to do their own self-cleansing. The other side, the people who were going to courts, they were going to find reprieve given the great haste that this matter was handled from the executive side. But it is also possible that the president was not fully advised as to those actions, and therefore he read the speech that he read. But and that's why I'm saying that it makes a lot of sense for the president to reach out, perhaps also to get some inputs beyond the circle of those who are advising him, because then he may have a more balanced view in regard to what is going on, and the address that he makes and the things that he says in regards to circumstances like this would not only be more robust, but it would also be factually correct. They started this business of the haste and the hurry. So for the next generation to address your point, I feel very, very sad that our judiciary should be brought to this kind of level, that the attempts to destroy rule of law should be so brazen in quite some ways. It's rather unfortunate. I am hoping and expecting that reason would prevail. Reason would prevail. We all make mistakes, but we also, the good news is we should also be able to acknowledge, okay, this course, it may not have been the best course. There should be a better way of handling this, and we should start retracting, we should start pulling back, and let us find a way to sort things out. And that is really what I am hoping for. I'm expecting that the executive arm of government would find reason, would see reason to pull back and reach out. Let us, whatever the problems are, whatever the issues are, whatever they want. So they want to remove the CJN, there's a process. Let's go follow those processes. And then things would be much better.
Well, how amenable they are to discussion would depend on what is driving this whole situation. What, in your opinion, might that be? What is causing all of this?
That would become speculative for me because I'm not a member of the executive. But you see, the thing about it is, whatever your motive is, if the law has stipulated that this is how you should achieve that your goal, whatever that motive was, then as somebody who swore to uphold the law, then it becomes incumbent on you to follow that process. If you follow that process well enough, you may be able to achieve your objective. You may be able to achieve your motive, whatever that motive is. But follow that process. And by the way, if you do not succeed, then simply also understand that the law was not on your side. And there's no need for you to find a back alley to still achieve the same thing. It just doesn't make sense. It destroys the foundation of our justice system. It destroys the rule of law itself. It destroys everything. And we need to have a society. See, if we are not a society of law and order, then we are going into anarchy. And we don't want to get into anarchy. So the best thing is for us to have a system that is governed by law, that is governed by order. So whatever the motive is, whatever you want to achieve, follow the proper process that is specified under the law.
Now, this situation has raised questions in the minds of the public about the probity of the judiciary. What can you, as the NBA, suggest is done to restore the public's faith in the judiciary?
Okay, I will answer that in two ways. The first one is, it's rather unfortunate that somehow we give way to what I consider to be mob justice, mob trial. And this is mainly, very unfortunately, also seriously, the predilection of agencies of the federal government. They start this media trial and they disparage people's names on the newspapers, media, social media. That is what has happened in the case of this CJN. They release those documents and they disparage him. It's totally, totally wrong. And they twist it as well. And they come out with those publications that say, oh, we have found some other things. Unfortunately, it found its way also into the president's address. That, oh, they have found some other things in regard to the CJN. If you have found them, package them, put them in a process document, file. In fact, in those publications, they have not even said that they have interviewed or they have interrogated in regard to some of those things. But you see... Are
you referring to the millions of dollars that the president mentioned?
Correct.
That's not in the 6-point charge. It's not.
Precisely.
Yes.
So, but you see, in the eye of the public, the man is already guilty. And you find, I personally see people screaming, wow, where did he make all of this? They haven't even asked him. So that has to stop. That truly has to stop. That is what creates that impression, that perception that there is something wrong as far as the judiciary is concerned. And in the process, you are destroying the judiciary. Unfortunately, also, the judiciary, judges are not permitted to come out openly to speak. The executive, you can go to anywhere, you can use the media. but judges are not permitted to speak. And you're being most unfair. And you know very well that they're not in that position that they can speak for themselves. And you're disparaging them. You're destroying the very foundation of justice. I feel very pained about it. It's not something that we should do. Where in the process, we are destroying ourselves. Because when you make the public lose faith in the judiciary, you destroy everything. It's not right. That's number one. Number two, let me say that you do indeed have facts that show that certain judicial officers, and by the way, that first one that you're doing, and you have effectively done a class defamation. You have destroyed the name of everyone. And it can't be that everyone in that place, they're all bad anyway. So there are some that you might think are not very good, or they are corrupt, or whatever. There's a process for you to discipline them.
Mr. Usoro, I'd like to ask you about your thoughts on this case, Barrister Ismail Ahmed versus Alhaji Nasiru Ahmed and others, 2013, on exclusive jurisdiction of the CCT on violations of the Code of Conduct contained in the 5th Schedule to the Constitution.
Okay, that is in regard, when you're going to decide, when you're going to talk about that decision, right, for a judicial precedent to be applicable in the case of, say, for example, the CJN, then the facts have to be the same. And when I say the facts have to be the same, the question that you need to ask whoever is prompting that question is, whoever that person was that the decision was made in regard to the exclusive jurisdiction, was he a judicial officer? If he wasn't a judicial officer, and then you have a case, as in this present instance, where the Chief Justice is a judicial officer, is there a constitutional provision that says you should follow a different process in regard to the asset declaration of the Chief Justice? That is the question. Precedents depend on the facts. In other words, the facts of that precedent, they must fit into the present one.
They have to be on all fours.
Exactly. So when you cite that authority, and I've seen people cite that authority, what they fail to mention is, are the facts in regard to that matter the same as the facts in regard to the present case? They're not. So what the NBA has been saying, and what the issue is in this other instance is there is a process specified by the Constitution for having to discipline judicial officers. And it is also part of protecting the sanctity and independence of the judiciary. And if a judicial officer is found to have misconducted himself, including not following the law that he swore to follow, and that includes the provisions of, in regard to asset declaration, then you have to take him before the National Judicial Council and let the National Judicial Council pronounce on that infraction. And if they find that he has infracted himself and discipline is imposed on him, the prosecuting agency's time doesn't lapse as far as criminal infraction is concerned. It doesn't expire. So you can prosecute him. Nobody says you can't prosecute him. Nobody says you can't take the CJN to the CCT, but there are conditions precedents. Follow those conditions precedent. And by the way, nobody's also saying that the NJC will take the place of the CCT. The thing is, follow the process, and then you can still take him to the CCT. So when they cite that authority for you, please let them understand that the facts are not the same. I've given you two distinguishing factors. And by the way, nobody's saying that he would not ultimately be tried by CCT, or that they're taking away that function away from the CCT. All that the NBA is saying is there is a process before it gets there. Follow that process before it gets there. And second, just note and let the person tell you whether in that authority he's referring to was the person a judicial officer. If he wasn't, then there is a distinguishing factor.
Wow. Thank you so much for being here today. And thank you so much for sharing this. I'm sure this is going to go a long way in helping people at least understand what to expect over the next week, but really also that the danger that we're all in when the rule of law is flaunted in this way.
Thank you very much.
Thank you very much.
Thank you. Thank you.
When we return, our Rise News analyst and producer Charles Owaku will be joining us to share and review top newspaper headlines from across the country. Stay tuned.